The government maintains that it may automatically strip Mr. Hamani of his Second Amendment right to possess a firearm because he uses marijuana a few times a week. That would be specifically, ladies and gentlemen, every other day at his admission. More than that, because he possessed a gun despite this prohibition, the government insists it may imprison him for up to 15 years and disarm him for life. According to the government, none of this turns on how much marijuana Mr. Hamani uses or what effect it has on him. And let me pull this decision up for you if you're watching. You can see it here on your screen. It makes no difference either if he keeps a firearm only in his home for self-defense, never misuses a gun while intoxicated, and never poses a danger to himself or others as a result of his marijuana use. The only thing the government must show, it says, is that an individual like Mr. Hamani regularly uses any amount of any controlled substance. To square that expansive theory with the Second Amendment, the government invites us to draw an analogy between its present regulation, weed ban, total, and historical laws addressing habitual drunkards. Those laws, the government contends, demonstrate a tradition of firearm regulation consistent with its effort to disarm any regular user of any controlled substance without any further showing. But the government's analogy fails under every measure it asks us to consider. The historical laws on which it relies targeted different kinds of people, did so for different reasons, and operated in different ways. And faced with all these shortcomings in the government's submission, we cannot say it has carried its conceded burden of showing its prosecution of Mr. Hamani complies with the Second Amendment. The judgment of the Fifth Circuit is affirmed. And I always love this in court cases, even my own. It is so ordered. Judges are powerful people, ladies and gentlemen. There's no question about it. Now, I'm going to give you a different take on this. Maybe not really a different take, but we're going to, obviously the Supreme Court ruled, and that's the way we're going to approach this. But there's a lot more going on here. Okay, so I'll give you some examples. If you've been scrolling through social media or reading any of the headlines that are out there on this thing today over the past, few hours, you've probably seen something like Supreme Court says marijuana users can own guns, or maybe something like SCOTUS strikes down federal weed gun ban in unanimous decision, which is something I put out as well because it's true. Or perhaps marijuana users win Second Amendment rights. Now, ladies and gentlemen, those headlines are obviously designed to get our attention, right? That's their headlines. We know that from our coverage of media here for years, headline surfing. But they actually don't tell you what the Supreme Court did. It's not even close. So I'm going to break this down. I'm going to give you some opinions here that you might not hear elsewhere because I'm looking at this through a different lens. I'm looking at it specifically through the strength of the Bruen decision. And that's how we're going to start the program with you today. All right, let's go into this. We actually read the opinion today, all 39 pages of it. We read the concurring opinions, and I'm going to quote some from Ketanji Brown Jackson. You're going to love this one, even though it's a concurring opinion. And maybe from Kagan, and maybe a little bit from Thomas. Thomas's was a little bit Thomas relied mostly on the Commerce Clauses where he focused his concurring opinion, albeit it was a concurring opinion. After reading all 39 pages of this that was written by Neil Gorsuch, for the majority, I can tell you this. This decision is far bigger and much narrower than the headlines would have you believe. It sounds kind of contradictory, ladies and gentlemen, but it's really not. Let's start with what the case was actually about, because it wasn't some broad declaration, if you will, that everybody who smokes weed can now own firearms. I'll explain some of that nuance. The court did not say that because it was narrow. In fact, they specifically said that they were not deciding the case or a whole bunch of related questions, I should say, in this case. Instead, the case involved one man. Of course, it involved Mr. Hamani. And according to the opinion, federal investigators searched his home during an investigation unrelated to marijuana. That was for a terrorism search, supposedly. Now, he was never charged with anything related to that. During that search, he cooperated with the investigators. The government admits that. He voluntarily surrendered a firearm in cooperation with the government in his home. He pointed officers to weed on the property, marijuana on the property, and admitted that he used marijuana about every other day. Months later, as I just mentioned, the government prosecuted him under 18 U.S.C. 922 G3, which prohibits an unlawful user of a controlled substance from possessing a firearm. You notice anything here? This case was not about violent crime. It wasn't about armed robbery. It wasn't about felons. It wasn't about someone waving a gun around while intoxicated, hammered, stoned, whatever. It wasn't about trafficking. It wasn't about gang violence, gang-related violence in any sense. It wasn't even about using a firearm while committing another crime. It was quite literally about possession. Possession inside his own home. And that's extremely important here as we break this down. Here's where the government made its argument. Federal prosecutors essentially argued, if you are an unlawful user of a controlled substance, you automatically lose your Second Amendment rights. Period. Done. Greg, the 4473, what's it say on it? Or what did it say on it? This is going to change. If you smoke pot, you answer yes on that question.
Yep.
You can't buy your gun.
Yeah, you're out of the background check. You're out of the purchase process. You're out.
You're being honest. And we have been warning people on this program for years, now 2 decades. You had better be paying attention to that, because if the government chooseth, the government canneth prosecuteth youeth. Okay? And many people have been. No hearing, no judge, no jury, no finding that you're dangerous. You just said, yeah, I smoke a little weed or I use a controlled substance. No gun for you. No soup for you. No individualized evidence whatsoever. Just you smoke marijuana in this case. Therefore, no guns. Yep. That was the government's position, period. Nothing more, nothing less. You smoke weed, no guns for you. Here's what Gorsuch asks in the opinion. Where is the historical tradition supporting this? This is where I'm going to drill down into this today. Because this decision, as you find as I go through all these pages of notes we've put together all day on this for you, what this means for Bruen going forward. We're looking at this through a little bit different lens, and going forward, what it means for future cases. Because remember, after Bruen, that's the test, ladies and gentlemen, the historical analog. Not whether Congress thinks it's a good idea, not whether a policy sounds reasonable to whoever it sounds reasonable to, which can shift and change, as you know. Not whether someone in Washington says it'll make us safer because they're Democrats and it's all about safety. The constitutional question is bigger. Did America have a historical tradition of this type of firearm regulation? That's the test that the court applied because of Bruen. Wait till you hear Ketanji Brown's concurrence in this. It's going to blow your mind. And Kagan's too. The opinion begins with the framework established in the Bruen decision from New York 4 years ago. If the Second Amendment covers the conduct, then the government has to demonstrate that its regulation is in fact consistent with the nation's historical tradition of firearm regulation. Clearly that test failed. Here's where the opinion gets really fascinating. The government didn't come into court empty-handed. They actually tried to argue this through the drunkard laws, habitual drunkard laws. We've always regulated habitual drunkards. It's an interesting argument. So interesting that Gorsuch spent pages discussing historical laws involving habitual drunkards. But there's a problem. When we come back, we're going to break it all down. Don't go away. Fascinating conversation today. We'll be right back. The government doesn't get to pick and choose your rights and decide who's dangerous. If you agree, hit the subscribe button and click the link below to watch the full SCOTUS breakdown. Stay free.